Hi, I'm Steve Murphy, and this is the Insider Exclusive. Today we're visiting with Houman Fahimi in Orange County. He's the founder of his own firm, Fahimi and Associates, and today we're going to be talking a little bit about his firm. We're going to be talking about two important issues, criminal justice and criminal defense, as well as employment law. So let me introduce Houman to the show. Welcome to the show, Houman.
Thank you, Steve, and welcome to Santa Ana to our office.
Now, there is another area that your firm specializes in, and I think you call it the employment team at your firm, correct?
Yes. What I've done is I have kind of distinguished what we do in our practice. Yeah. We call it our criminal defense team and our employment law team. You know, I talked about my investigators. I talked about the experts we use. Well, the investigators I use in my criminal defense are completely different than the investigators we use for our employment law cases. The expert we use for our employment law cases are completely different. It's two different areas of law, and I feel pretty competent that I'm well experienced in both of them. As I explained, I've been a general counsel to a local public company for 5 years, and I have sat on the other side. I have seen when you're getting rid of an employee, when you're terminating an employee, when you're firing an employee, retiring an employee, what considerations go into deciding how best to approach this? Could this turn into a lawsuit? Do I want to offer him a severance package? What should the severance package include? Mm-hmm. I am now bringing that to employees. Mm-hmm. And when I get a call from an employee who says that I was terminated, I think I can honestly sit down and advise them and many times people walk into my office and they tell me that they feel like they have a case. And after listening to them for over an hour or so, I honestly tell them that I don't think you should pursue this because there's no legitimate case here. So that aspect of the case deals with former employees, sometimes current employees, and we do represent a few employers.
Now, tell our audience a little bit about the ways that employers try to cheat employees.
Well, the biggest one obviously is if you're terminating an employee and you're calling it a cutback or reduction in force, and in effect you're terminating that employee because of discrimination. You're discriminating against that person, or you're retaliating against them. That's one way, if you can call it cheating. The biggest way is how employees are cheated out of the wages they have earned, be it overtime wages, be it bonuses they have earned, commissions they have earned, not receiving proper meal breaks, not receiving proper rest breaks. And there are many ways employers do this. I actually had a case, we tried this case in which this was a father and son, very successful. They had a chain of stores. I'm not going to get into details because it could come, we don't want anyone to find out who they are.
So you settled this case? No,
we went to trial and we won the case,
right.
But I still, I still like to keep a degree of confidentiality. They had a series of stores which in retail business, and they had incorporated each of these stores under a separate name. Yeah. I think I discussed it with you before. So what they would do is, for instance,
I've seen this in the nursing home industry.
Do you really?
And the trucking industry.
Yeah.
Go ahead.
Yeah. So what they would do is they would have a store in Santa Ana, one store in Huntington Beach, one store wherever. An employee would work in the Santa Ana store, clock out, go over to the Huntington Beach store, work there another few hours. Combined hours were well over 8 hours. But the fact that they were divided into two stores, they wouldn't give them any overtime.
Would they give them two separate checks?
Two separate checks, yeah.
Really?
They would go through all of these things, all these expenses, just to get out of paying.
I mean, on the surface of things, when you go to court, it's pretty blatant what they're trying to do, right?
If they know what they're doing.
Yeah.
If they have hired good lawyers, they could cover it.
And a lawyer recommended that?
Well, again, if they had done it the right way, they may have been able to cover themselves. Yeah. They hadn't, because we were able to easily establish that these were the same father and son shareholders. Yeah. They used the same accountants. Yeah. They used the same advertising company. Right. The same person who called and said, go to store A, called them and said, go to store B.
They had commonality.
Exactly.
Yeah.
So we were able to, in essence, establish they're all alter egos of each other.
What are some of the most common problems that employees come in and talk to you about?
Many employees feel like they were discriminated against when they were terminated. issues of overtime wages is huge, because as you know, overtime is not just time and a half, but at a certain point it becomes double time. And there are many companies which don't honor the double time. There are many employees.
By the way, I'm just curious, when does it kick in to be double time?
12 hours.
In one day?
12 hours.
So between 8 and 11:59, it's time and a half.
Between 8 and 11:59 is time and a half. Over 12 is double. Or if you work 7 days in a row, the 7th day will be double time.
Really? That's California law.
That's California law.
Yeah. By the way, California is a pretty friendly state for employees, isn't it, as opposed to other states?
It is, and by employees, I think it's just more fair. For instance, federal law provides for overtime wages, but federal law applies to the 40 hours a week. California talks about 8 hours a day, 40 hours a week. But yes, California gives more protections to employees.
Let's talk about discrimination, types of discrimination that you generally encounter.
Age discrimination is becoming pretty prevalent nowadays. Now with the economy taking a downturn, what I'm seeing a lot is discrimination based on pregnancy. I've had many cases in which the employee is terminated once the employer realizes that they're pregnant. They will eventually go on a leave. And even though that leave is unpaid for, the employer is concerned that, well, maybe she's not going to be able to do the job as well, and now I have to wait for her to come back.
And they are under obligation to offer her job back, aren't they?
Well, let me put it to you this way. In order to establish pregnancy discrimination, I have to prove that the pregnancy was, quote unquote, a motivating factor in her being let go or not getting that job back when she came back.
But by law, she is allowed to come back to her job after her non-paid maternal leave, correct?
She is, but the employer can say we don't need you anymore. And if the employer can show that they said we don't need you anymore and had nothing to do with her pregnancy, then they don't have to take her back.
You had brought up before the show that you wanted to talk about the ways that unscrupulous attorneys try to shake down businesses and how to avoid it. What did you mean by that exactly?
Well, you just mentioned that California laws are employee friendly, and they are. There are a lot of rules in place so that the employees are not taken advantage of. For instance, I'll mention one of them. One of them is that every employee who has to receive a pay stub. Okay, and these pay stubs have to be, establish how much taxes they were taken out and certain other pieces of information. Some employers don't do pay stubs. They pay the employee on time. They pay him all the wages they're owed. They just write him a check and hand it to them. Well, that's a violation right there, and that violation could cause the employer to be responsible for damages.
Okay.
Many attorneys will look for small violations like that. They will go after a small mom and pop operation. And what they will do is they will say, look, you let my client go for pregnancy discrimination, whereas there is no facts, there is no evidence that discrimination had anything to do with her being let go. The employer will get angry at that and will say, I'm not going to pay you a penny, I'm going to win this case. Lo and behold, the employer was paying her without doing the pay stubs. Now that attorney can use that pay stub violation as a fallback and drag this case out. And even if the pregnancy part is lost, if he can win on the pay stub part, he gets his entire attorney's fees. The employee really gets nothing, the $4,000 violation.
See, do you have a lot of attorneys? Are there a lot of attorneys doing that?
There are some attorneys who are using that. And anytime I get calls from small businesses.
So they're looking for something else.
Technicalities.
So they can squeeze money out of it.
Exactly, technicalities. And my advice is, contact a competent attorney, and if they come to me, if someone like that comes to me, I will say, don't let your ego get the best of you. You're going to lose this $4,000 part of the case. The important thing is cut off the attorney's fees right now. Offer them $5,000 or $4,000. As much as you don't like it, you screwed up. You should have had pay stubs. Don't let this thing drag out for a year and that guy build up his attorney's fees.
What are some of the other areas in employment law that you see people coming in here complaining about or looking to file a lawsuit?
The issue of not receiving their commissions is an important one.
Salespeople.
Salespeople. Again, salespeople, the law is if you had something to do with that sale and the preconditions are met, the commission is yours, even if you're fired. once a commission is earned, you have to get it. Now, you may not get it after you left. So if you're an employer, make sure your agreements with regards to commissions are written in stone, and so it's pretty clear when the commission is earned.
It seems that over the last 15 years you have earned and learned a lot of experience in handling both employment as well as criminal defense cases, and I think that and that alone should make someone feel comfortable of selecting your firm in handling those two areas. And I really appreciate you spending time with us today, and we certainly hope you have come back again.
Thank you, Steve. It was very good meeting you.
You're welcome.
See you.